Hello, and welcome to our October 2023 Financial Services Seminar on the perimeter, Do I Need to Be Authorised? Today's topics, which are of relevance and we're encountering them very often in terms of client needs and client business, are the Bank of Mum and Dad and loans from the Bank of Mum and Dad, introducers and financial services and how that impinges upon regulated activities, and raising business funds and financial promotion. I think everybody in this room will have experienced issues relating to each of those topics, but one of the more interesting questions to grapple with is whether or not you need to be regulated or how potentially you can avoid a need for regulation if you are engaged or you have clients who are engaged in any of these particular areas. And I think that will apply to most professional services firms at the moment. Who am I? I'm Christopher Moss. I'm a partner in our corporate team and I head our financial services sector grouping here at Meyerson. Our financial sector services grouping is a multidisciplinary, cross-departmental group of people, all of whom have experience in the financial services sector in different ways. My contact details are on the slide, and in terms of our group, between us, we have an experience of day-to-day dealings with the FCA. We deal often for mergers and acquisitions activities for our clients, including change of control and the notifications required to be given to the FCA on a change of control. We deal with the FCA on a day-to-day basis for certain clients in relation to compliance issues, and we give day-to-day compliance advice. In the past and currently, I act for David Fishwick, who may be familiar to you from The Bank of Dave, and if you haven't caught the film, it might be worth you doing that. We very often see clients coming to us with issues around personal loans from friends and family and fundraisers. Fundraisers are very interesting from a corporate perspective because, of course, every company under the sun seems to need money. There are some very interesting regulatory angles to that, which we'll explore in a moment. Mergers and acquisitions activity is another main focus for us at present. The industry is in something of a state of flux, and some of the change of control issues and some of the fundraising issues may be germane to that. Before we get into the detail on each of these topics, it's worth going through some background. I apologise to those of you for whom this is old news, but actually it's quite important sometimes to remind yourselves of the basis upon which all this sits. The Financial Services and Markets Act 2000, FSMA, and I'll refer to it as FSMA going forward, will be known, I think, to everyone. But it is the granddaddy of a whole swathe of legislation which covers financial services, and it gives rise to some very interesting questions and problems. The key initial aspects of the regime that I'd like to just focus on for a few moments are regulated activities themselves. How does that work? Financial promotion, which is very relevant to any communication around a regulated activity, and collective investment schemes. Collectives are interesting from the perspective of corporates seeking to raise finance. And you always have to have collectives in the back of your mind when you're considering what you're doing and how you are going about the raise. Firstly, what's known as the general prohibition, Section 19 of FSMA. No person may carry on a regulated activity in the UK or purport to do so unless he is authorised or exempt. We can almost ignore exemptions for present purposes because there are very few and they tend to relate to governmental or government-related activities. Authorised, of course, means authorised by our old friends, the Financial Conduct Authority, FCA. Regulated activities are defined and set out under and in legislation made pursuant to Section 22 of FSMA. An activity is a regulated activity for the purposes of FSMA if it's of a specified kind, carried on by way of business, I'll come back to that in a minute, and relates to a particular type of investment, investment of a specified kind, or is carried on in relation to property of any kind, where that property is specifically specified as being an investment for the purposes of the Act. I think the first thing to say is that investment of a specified kind is a very interesting smorgasbord of things, and one has to look at something called the Financial Services and Markets Act 2000 Regulated Activities Order 2001, commonly known as the RAO, to actually discover what that list of items is. The RAO has undergone almost constant revision since it was first incepted in 2001. New activities seem to be added almost on a monthly basis, and certainly every 6 months there'll be something new that's added to the mix. But I think for present purposes, if we simply think about investments in its common or garden sense, shares, stocks, debentures, options, warrants, futures, anything that looks and smells like an investment is on that list. Certain types of loan are also on that list as a throwback from and as a springboard from the consumer credit regime, which we'll come on to talk about when we talk about mum and dad and Bank of Mum and Dad. In relation to by way of business, it's worth noting that there is some interesting guidance on this, and we'll look at that again when we look at Bank of Mum and Dad loans very shortly. By way of business is a fascinating concept and is very fungible, but it is a very, very useful thing to bear in mind because many people forget that the activity has to be carried on by way of business for it to fall foul of this legislation. The legislation also covers information about a person's financial standing. This was brought in fairly recently and was brought in to deal essentially with credit reference agencies and related disciplines. The next big plank of this legislation is Section 21. These are the restrictions on financial promotion. So this is actually promoting and going out and talking about and advising upon and counselling people to enter into investments. What Section 21 says is that a person must not, in the course of business again, communicate an invitation or inducement to engage in an investment activity. Claims management is also mentioned on the slide because that's also regulated, but it's not today's topic. Subsection 1, so this prohibition, does not apply if the person is an authorised person or the content of the communication has been approved by an authorised person. Any approvals for Section 21 purposes have to be very specific, and they have to actually narrate that the approval is for Section 21 purposes and set out who the approver is, their registered number, their FCA number, etc. There has recently been a lot of movement in FCA's approach to approvals of someone else's investment advertisement, to the extent whereby it is very much frowned upon these days, and one has to do an awful lot of due diligence if you're going to actually look or even think about approving someone else's investment advertisement. If anyone does actually have experience of that or has problems with it that they would wish to discuss, we'd be happy to talk to them. The key thing, though, is the core prohibition, which on the face of it stops anybody from inviting or inducing people to engage in an investment activity. So this doesn't, according to the FCA's perimeter guidance, catch ad hoc communications, generic communications, things which just say this particular item is out there. It has to be specific to a particular investment, and it has to be essentially an invitation to put your money in. There are a whole number of exemptions to this prohibition. There have to be. These exemptions are contained in the Financial Services and Markets Act 2000 Financial Promotion Order 2005, commonly known as the FPO. These exemptions include exemptions for intermediation, so people who are simply passing a message on, generic communications, investment professionals, so communication to someone who you know is routinely involved in investment work, and sophisticated, high net worth individuals subject to certain very specific criteria about how those individuals are identified as sophisticated or high net worth, and the risk warnings that are to be communicated to those individuals. It's not enough to simply identify someone who has a lot of money or spare cash and say, oh, he's high net worth. There is a very specific process that has to be gone through, and that is very often not observed. And that can be a big problem. There are also exemptions for things like takeover, certain employee share issues. There is a business angels type exemption, which may be relevant when considering the issues around fundraising. But generally speaking, it is a very blanket prohibition, and a lot of people fall foul of it without even knowing about it. Something about territorial extent. Very often you see companies which communicate over the internet who may be overseas, but they're offering potentially investments that people in the UK can take up. Very good example might be Coinbase, which is Irish-based. So what the section says is, in the case of a communication originating outside of the UK, the prohibition applies only if the communication is capable of having effect in the UK. So basically, if it touches or concerns people inside the UK and the investment itself has effect in the UK, then it is caught under the prohibition. This potentially extends the jurisdiction outside of the UK itself, and it will be very interesting to see how the FCA responds to certain of these websites that have sprung up in overseas countries that are inviting subscriptions from UK nationals. Let's turn now and have a quick look at the starting point for looking at Bank of Mum and Dad loans. So regulated activities around lending. The following sections all relate to parts of the Regulated Activities Order, the RAO, and the regulated lending sections are all to be found in Article 60 and its following sections. Firstly, 60B says, entering into a regulated credit agreement as lender is a specified kind of activity. So borrowers aren't caught. You have nothing to worry about as a borrower, apart from the fact that your lender may be dodgy. It also goes on to say that it's a specified kind of activity for the lender or another person to exercise or to have rights to exercise the lender's rights under a regulated credit agreement. So what is a regulated credit agreement? The legislation pre-2014 essentially was caught under the old Consumer Credit Act regime, and that has a very specific set of issues relating to it. Most of those agreements are now dead and defunct, so we'll ignore them. Exempt agreement is a credit agreement which is exempt under one of the following articles. Where only part of an agreement is exempt, only that part gets the exemption. I know that sounds a bit tautologous, but it's the case that if a part of an agreement is caught, effectively you're falling under the regime, and if you're required to be authorised, if you need a permission, you should have the permission, otherwise there are consequences which we'll come on to. So what agreements are exempt? Broadly, there are some categories. It includes regulated mortgage agreements and home purchase agreements, largely because they're separately regulated under another section of the RAO. It exempts provision of credit for a borrower's business over £25,000. We'll come on to that in a little bit, but fundamentally there are some very specific declarations and some specific wording that is required in the agreement to actually enable it to take advantage of the exemption, and it's very much at the lender's risk if it turns out that that is wrong and that actually the loan itself is not for a business. So you can't necessarily rely on just bunging some words in a document and you're all right. It doesn't work like that. Let's look at land, because very often the scenario that we encounter is something whereby mum, dad, brother, sister, uncle, aunt, grandparents might want to lend something to someone to buy a home. There is an exemption for the purchase of land for non-residential purposes. There are some very specific criteria that apply to that, but it's pretty rare to find one of these exempt agreements, largely because you don't see a lot of non-residential land changing hands or a reason for lending in relation to it outside of the agricultural sector. Secondly, there is an exemption under Article 60F for effectively short-term borrowing. This is borrowing over 12 months where there are not more than 12 repayments, and those repayments are required to be made within 12 months of the date of the agreement. 60F3 exempts certain agreements for borrowing where the asset being secured upon is not land. So a credit agreement is exempt in relation to that if it is a borrower-lender-supplier agreement. So that's an agreement where I borrow money from someone to pay for something from somebody else. For running account credit, so general credit purposes, not necessarily anything specific. The borrower is to make payments in relation to specified periods, which, if it's non-land, must be 3 months or less. So this is, again, short-term agreements. Only short-term borrowing agreements can fall outside of the regime. The number of payments that the borrower can make in repayment of the whole amount is a bullet. You've got to have a provision whereby it's repayable in one lump sum. Next. In relation to land, there is an additional exemption where the agreement is a borrower-lender-supplier agreement to finance the purchase of land. So again, I borrow from someone to buy land from somebody else, 3 parties. The number of payments in relation to land is slightly higher, but not more than 4. The credit is secured on land or is provided without any cost, without interest or other charges. Note that this allows for slightly longer term agreements than the 3 months in relation to non-land transactions. In relation to other types of agreement, agreements are also exempt if, again, it is a borrower-lender-supplier agreement, this time for fixed sum credit. So this is a defined amount, not something that could be open-ended. And it's to finance a premium under a contract of insurance relating to land or anything on land. The lender has to be a lender under the credit agreement for the land secured by a legal mortgage on the land, and the credit must be repaid within 12 months in relation to the contract to which the premium relates. So again, short-term borrowing to pay your insurance policy related to a purchase of land, essentially. In relation to agreements to purchase land, there is also an exemption where the agreement is secured on the land, where the borrowing is at no charge than the interest at a rate not exceeding a rate of interest payable under the main agreement. So this is, for example, where you have an additional agreement or an agreement to borrow more, and it's tacked onto an original agreement. So essentially it's brought back into the original regime that governed the original agreement. So let's sort of cut to what people are probably wanting to know a bit about, which is, I want to loan somebody, say a family member, my son, some funds. Let's say it's a personal loan, and let's say it's unsecured. How does that work? I think the first question is this for a business or is it not? If it is for a business, then we are into the earlier sections which deal with the provision of certain types of credit for business purposes and putting the declarations in relation to business purposes into the documentation and making sure that that is robust. That is fine. If it is not for business purposes and it is unsecured, is it for 3 months or less? Is it repayable in one lump sum? What are the charges for credit? Again, does it actually agree with the sections that we have previously highlighted? Let us say that you have a loan which is secured on things which are not land. So this time a secured loan as opposed to an unsecured loan. Essentially the regime is as I have just outlined it in relation to personal unsecured loans. One has to essentially establish whether or not this is for a business purpose or whether it is not. Perhaps it's worth saying something as well in relation to gifts fee loans. So quite often family members might want to make a gift, and that's absolutely fine. That's not caught by the regime at all. The difference obviously between a gift and a loan is that with a loan, the person making the loan, giving the money out, has a right, a legal right to receive it back. On a gift, they don't. Let's say that the loan is going to be secured on land, and more particularly on land which is going to be used for residential purposes. Well, we're back to the points that I was just making in relation to the loan itself having to be repaid within certain timescales and within boundaries of certain rates of interest. One of the most common things that we do encounter, and the most common get-out clause, if you like, in relation to this whole area where you have family making loans to family, is the by way of business test. And that goes right back to the very start of this talk in relation to, is the activity being conducted by way of business? Most Bank of Mum and Dad loans won't be by way of business, hopefully. So they would fall immediately outside of the regime. But I don't think it's really enough these days to simply say, oh, that's the case. It would be very, very wise, particularly from the part of a lender who wants to get their money back in due course, to actually have documented precisely why this falls outside the course of business and why it isn't being done for a business purpose. Having that documentation and having the evidence at the time will be extremely useful if the FCA ever does knock on your door. The FCA has issued some perimeter guidance in relation to by way of business under its perimeter guidance manual. This is an extremely useful document, and anybody who's looking at this area really ought to take the time to look at the perimeter guidance. What it says is that by way of business is a question of fact and degree. You look at the frequency of loans, the size of the loan, and particularly the commerciality of the loan. So if I am a person who is making multiple loans to son, daughter, uncle, cousin, or anybody else who may have some sort of more tenuous connection, maybe cousin's brother's wife's mother or something, then you would have to look potentially at the commerciality of that. Is this person who's making all these loans doing it generally? Is this really looking like and feeling like a business that they are undertaking as opposed to a bit of philanthropy? Consequences of getting it wrong. Firstly, it's a crime. One of the things that people tend to forget with crimes is the criminal proceeds regime under the Proceeds of Crime Act. So whenever there is a crime or a reasonable suspicion of one, certain individuals, particularly professionals, are under obligations to report it, and transactions cannot proceed without clearance. In contractual terms for the lender, it's a disaster because the contract is voidable by the customer. So the customer can say, this contract is dust, and the contract is unenforceable by the lender unless the lender trots off to court and gets a court order, which is by no means guaranteed to be forthcoming. Final slide on this particular topic, and just one word, advice. if anyone is entering into any of these arrangements, as you will have seen from some of the size and complexity of the previous slides, this is a bit of a minefield, and we can help you navigate it. But whenever a client is going to be looking to do anything of this nature, they should get good advice on it before they proceed. Article 25 of the Regulated Activities Order essentially prohibits or makes subject to regulation the activities of arranging, that is, bringing about transactions in investments, 25(1), and making arrangements with a view to transactions in investments, that's 25(2). You will see that the second limb, making arrangements with a view to, is a lot wider than the first. The first limb is pretty clear. If you bring something about, then that's caught. But making arrangements with a view to can have all sorts of different bit part meanings in relation to an overall transactions. I think in relation to investments, it's worth remembering that the investments that we're talking about are the specified investments, that is, that whole gamut of stocks, shares, debentures, bonds, options, warrants, futures, the whole range of investments that fall within the specified investment regime. The FCA has given perimeter guidance in relation to making arrangements and arranging. And the perimeter guidance says, particularly in relation to making arrangements with a view to, that those arrangements have to be of sufficient importance such that without the involvement of the introducer, that's the person who is in question here, the transaction itself would not have occurred. That's quite important when we look at the case law in a moment. There is also an exemption under Article 26, which is arrangements which don't cause the transaction. Again, it should almost go without saying, but some of the case law has looked very closely at that article. So what might an introducer be doing? Simply opening a door from one person to another, that's fine, particularly if it's on a non-remunerated basis. That's simply opening a door. That's not really making arrangements, and you'd say that that fell within Article 26 all day long. That person has not caused the transaction to occur. Some introducers, however, have the power or authority to negotiate terms. Some introducers have undertaken marketing or sales activities. Some have said, oh, I'll help you with the paperwork. I can help you fill in the forms. And there's always a question with an introducer as to whether they're acting as principal, so that is on their own account. Am I doing this just for me? Or am I the agent of the person who's promoting the investment? In which case, I'm an arm of that promoter. Is that promoter regulated? First case I want to really look at, or first two cases, are Watersheds, which is an old case from 2009, and Avocade, which is a very recent case and may well be appealed. Court of Appeal Authority, Avocade. Watersheds concerned an unauthorised corporate finance firm which arranged funding for a business and effectively transacted both for the business and the person putting the money in. It was held in that case that what the arranger did, what the introducer did, was no more than effecting an introduction from A to B. Watersheds caused a bit of a furore at the FCA, and they were heavily against the decision at the time, but didn't appeal it. The FCA got their way, ultimately, in Avocade. Avocade concerned Section 25(2), and again was an unregulated introducer, but people who had introduced, done some marketing for the particular proposition and product. They'd also helped the investors complete their paperwork and their application forms. The court considered whether or not you could construe the different strands that the introducer was doing there independently. Are they being paid separately for marketing services? Are they being paid separately for the paperwork completion? In this case, there was evidence that Avocade were. The court essentially said no. You've got to look at the whole bundle of what is going on. And if the whole bundle is such that arrangements are being made by this introducer with a view to the transaction occurring, and that but for the introducer's arrangements, the transaction would not have occurred, then you fall within the section. I'm not going to touch at this stage upon Adams, but Adams may give introducers a little bit of cause for hope, because Adams rode back a bit from the but-for test that Avocade had potentially advocated. Time is running short, but I'd like to look at fundraisers by companies, which is an absolutely common topic, I think, for all of us. Everyone needs money. But what's the actual background, and where does the legislation impinge upon it? First piece to look at is the Companies Act. Section 756, what's an offer to the public? Am I going out to the public for my money? An offer to the public unhelpfully includes an offer to any section of the public, however selected. That can be a very small section. There's some ancient case law that says that it could be two or three people, could be an offer to the public. However, Section 756 of the Companies Act helpfully says that an offer is not to be regarded as an offer to the public if it can properly be regarded as not being calculated to result in the securities becoming available to people who haven't received the offer. So if you can keep it tight, then you can fall outside of the offers to the public question under the Companies Act. However, that's not the whole story. An offer is to be regarded as a private concern of the person receiving it and the person making it. And again, this falls outside of this test. If it's made to someone who's already connected with the company, or it's made on terms where the people who are making it and receiving it are essentially all connected and connected with the company. This also includes employee share schemes and the rights to swap shares as between people entitled under those employee share schemes. I said that the Companies Act wasn't the be-all and end-all, because the other question that you always encounter is, do you need a prospectus? The UK prospectus regulation, which replaces the previous European Union law on this matter, says securities shall only be offered to the public in the UK or admitted to trading on a regulated market, so you can't list them either, after prior publication of a prospectus. FSMA Section 85 has specific requirements in relation to the publication of a prospectus involving transferable securities. That largely deals with listed stock, but the requirements for the prospectus across both particular pieces are such that there are detailed content requirements within the prospectus regulation, and that is also subject to UKLA, that's the UK Listing Authority's sign-off, whether or not the shares are going to be listed on a UK stock market. What exemptions exist? There are some. Firstly, the old EU passporting regime has now gone, sadly. You can, however, still avail yourself of what used to be the old EU exemption of making the offer to fewer than 150 people, and that will exclude people who are called qualifying investors. Qualifying investors are essentially professional investors. If you would satisfy the test under the Conduct of Business Sourcebook as a professional investor, professional counterparty, you're exempt from the 150 number. Secondly, if the raise is for less than €1 million over 12 months, that's going to include practically every SEIS raise and quite a lot of EIS ones. Thirdly, if the maximum consideration that's being raised over 12 months is €8 million or less. So again, small offers, you don't need a prospectus. Fourthly, commercial paper. The actual investment size itself, the minimum size of investment, is not less than €100,000. So again, that's big chunks of money. You don't need a prospectus for that. There are also some specific exemptions for takeovers, bonus issues, scrip dividends, things like that. The thing to bear in mind, even if you are exempt from the prospectus regime, is that the financial promotion regime and the restrictions around that still apply to the promotion of the investment. So you'd still have to look at whether or not you fell within one of the exemptions under the FPO, or whether indeed the material itself ought to be authorised by an authorised person, and indeed whether the authorised person can actually give that authorisation, the way the FCA are now treating those types of sign-off of someone else's marketing material. Under the 2012 Financial Services Act, there are very, very specific stipulations around misleading investments in investment advertisements. So you have to be very careful about the content of any information memorandum that is prepared. There are also some specific requirements for regulated firms under COBS 4. I would be very happy to deal with any questions or queries if you would like to call me or email me. And it has been a pleasure giving this talk to you. Thank you for listening.